Breaking news in the Mistay family murder case here on the Law and Crime Network. We're told that the reason court took this 10-minute break that it launched into about 6 minutes ago is because a juror is sick. We don't know many more details beyond that. We don't know if it's because of the graphic nature of the testimony and the photos that have been up on the screen for quite some time this afternoon. Yet another medical examiner has been on the witness stand showing pictures of the McStay family's remains, and those pictures have become more and more graphic as time has moved along in this case. I think I want to bring attorney Nicole DeBorde into the discussion here. She's with me on the Law and Crime Network. Nicole, can you hear me okay?
I can.
Okay, great. I can hear you. We launched into this very quickly here. Not much of a surprise, though, that a juror is ill. That happens. It's cold season. But we're speculating a little bit here, but we're wondering if it may be because of the graphic nature of the images that have been on the screen.
Sure, it's definitely a possibility. And one thing that we do hear from jurors with some frequency in these kinds of cases where there is really such horrific and detailed forensic evidence is that they internalize it, and people do become ill and very emotional.
Yes, and you know, we started seeing these pictures last week. We started seeing the images of the family being recovered in that shallow gravesite out in the desert. And those images have progressed to today show images of, I think it was Joseph's skull with the hair partially attached, and then the medical examiner saying, you know, we had to take that off. So we're getting more and more gory as time continues. But prosecutors think this is necessary because they're trying to say, hey, look, despite the remains as they exist today, all in pieces, despite that, it's possible that these suspected hammer blows may not have broken the surface of the skin and therefore may not have resulted in a lot of blood loss. And that plays into the prosecution's theory that these folks were killed in their home, yet the home does not have any official evidence of blood. The only thing prosecutors have are these little tiny droplets that a few people think might have been blood, but they weren't even discovered until images, photos taken of the scene were developed or brought back and put on a computer and then enlarged. So this is really key testimony. It's just not good for the stomach.
Absolutely, and I think that the prosecution's right. It's absolutely necessary. This is oftentimes an area for much arguing with defense attorneys. You know, they don't want these graphic and scary and sad images to go into evidence in front of the jury because they are so emotional. And oftentimes the judge is in the position to say, well, if this is what the prosecution is accusing the defendant of doing, then the defendant must live with these results.
Exactly. Okay, Nicole, we'll check in with you again in a couple of minutes here as we wait to see how long this break is going to take and hope to try to get some more details for you as they roll into us here at Law and Crime. We're not officially sure why the juror is sick. We're wondering, though, if it has to do with some of the images on the screen. In the meantime, let's listen back to some of that key testimony from the medical examiner who was on the stand into the afternoon. This is some more testimony from her.
Now, could an injury like this occur without there being any actual blood that comes out on the outside of the skin?
Yes.
How could that occur?
Because you will have blood coming out of the skin if there was a laceration, an open wound. With a trauma like this, you're definitely going to have external injuries, but it could be a bruise or an abrasion. It doesn't have to be a laceration.
How about some of the other fractures that we looked at with respect to Summer McStay? Is it possible for those injuries to have occurred without external lacerations?
Based on the number of pieces of skull that are broken, you would expect that there would be some lacerations, but not all of these skull fractures need to have an overlying laceration.
So is it possible that you could incapacitate somebody to a certain degree, because you can't tell us how many of these fractures occurred at one time? Is it possible you could incapacitate somebody to a certain degree without causing a laceration to the skull with blunt force trauma? Medical evidence that you observed that could tell you if she was raped?
No.
What type of evidence would you need actually to determine whether or not a rape had occurred in terms of tissue?
In terms of tissue, you want to see if there's trauma to soft tissue of the vaginal area.
And because there was no tissue attached, you cannot make any medical determination that that occurred. Is that correct?
Correct.
Were you able to determine the cause of death?
Yes.
What was that?
Multiple blunt force injuries to the head.
And were you able to determine the manner of death?
Yes.
Some of the previous testimony from the medical examiner on the stand this afternoon. An update to the breaking news we brought you a couple of minutes ago about a sudden recess in the McStay family murder case involving a juror who is ill. We're hearing that something didn't agree with the juror's stomach, but apparently the juror is feeling better now. What's going on? Is it possibly because of the graphic nature of the images that have been playing across the screen as the medical examiner's testimony has continued? We do understand, again, court will be starting soon. We'll bring you back there live as soon as things pick up. In the meantime, I want to dip back and listen to the key point made by that medical examiner just moments before the break was called, and that involves whether this vicious attack, allegedly by a hammer, would have resulted in blood loss. We're going to bring you there in a couple of minutes, though, folks. Nicole DeBorde, I think you're still with us, so let's mull on this topic again here. You know, the prosecution's been saying, as we were discussing a little bit earlier ago, that, you know, hey, look, there's not a lot of blood in the scene. Why is that? A lot of people are assuming, hey, look, there's this attack with this small sledgehammer. I say small, but it's still a heavy hammer. You know, there'd be blood everywhere. And, of course, defense attorneys oftentimes reference that. And it doesn't always happen that way. It doesn't always happen where there's going to be massive blood loss in a crime like that. And that's what this medical examiner was talking about.
Exactly. And, you know, it goes, this is sort of restating the obvious here, but, you know, you don't break the skin, you're not going to have blood. And if this was blunt force trauma that knocked these folks unconscious but didn't break the skin, or even killed them and didn't break the skin, you're not going to have blood necessarily at the scene. So it may or may not mean that they were not killed in the home just because there's no blood found at that particular location.
Yeah, this is going to be interesting to see how they continue to argue around this. Nicole, I think we have court activity picking up yet again this evening here in the McStay family murder case. If you're just joining us, defendant Charles Chase Merritt facing murder charges connected with a possible death penalty if convicted, involving the deaths of his business partner, Joseph McStay, 40 years old, Joseph's wife, Summer, age 43, and the McStay's two boys, Gianni and Joseph. Gianni was 4, Joseph Jr. was 3. Let's go back in for live testimony.
I can see it.
A pause there in testimony in the McStay family murder case. Nicole DeBorde with me on the line here at the Law&Crime Network. Nicole, we just heard the medical examiner reference that sledgehammer, and if one uses one's imagination, it's relatively apparent that that sledgehammer would fit in the hole in the skull on the right there, Joseph McStay.
Absolutely. I mean, the testimony is just brutal, gruesome, and graphic. It's really hard to hear.
Exactly. Okay, we have cross-examination of this witness starting. It'll be curious to see how the defense deals with this supposition from the ME that there might not have been a lot of blood loss.
I don't know.
Back here on the Law&Crime Network as we cover the McStay family murder case, this is cross-examination of a state medical examiner. Attorney Nicole DeBorde is with me here on Law&Crime. So, Nicole, I thought the cross-examination there was pretty effective, where the defense said, hey, look, you'd start to see blood pooling because of these types of injuries. The defense tried to get the medical examiner to say the blood loss would be significant. She didn't go quite that far because she said that was subjective. I thought this was an effective takedown of some of these opinions earlier, that there would not have been a lot of blood lost.
I think he's doing a great job. He's breaking this down moment by moment, getting this somewhat technical scientific evidence to make sense on a timeline, and help the jury understand that if the prosecution's theory were true, we'd be seeing more blood in the house. It doesn't mean that that the same defendant didn't kill these same victims in the desert, but it's certainly a very good line of questions by this defense attorney. Yeah,
and also towards the end there, we saw some testimony saying, hey, I thought they were trying to go towards like cast-off blood. Is that what you took away from that as well? In other words,
Absolutely.
if there's a repeated strike, then it wouldn't just come off the wound, it would come off a hammer, and it would hit the wall or whatever else is there.
Absolutely. I think that this defense lawyer is trying to paint a very vivid picture of what this crime scene should have looked like if the prosecution's theory in this case were correct.
Okay, so let's say the prosecution's theory is correct. Then where's the evidence of it? Is the prosecution going to say the house was painted? Are they going to say that it was cleaned up? Or where does it go from here?
And that may be the reason for such detailed questioning about the paint in the house. The other possibility is that, blood doesn't transfer if something is blocking it. In other words, were the victim's heads covered if this took place in the house? Were there, mats or sheets or barriers placed around where these individuals were killed? Or were they just killed somewhere else?
A lot of questions here. Bottom line, state has burden of proof, so if the state wants to win the case, the state needs to provide answers. We are going to take a quick break here on the Law and Crime Network. We'll be back with more testimony in the McStay family murder case when we return.
Now, at some point, did you have a conversation with your boss, Mr. Martin, about the difficulty with getting the fountains?
Yes.
And what, if anything, did you do in terms of trying to get the fountains after that conversation?
I kept a record of every time I spoke to somebody within that organization. Each time a check was written, each time there was conversation, there was an email, and Jeff had asked me to just get in contact with whomever I can to get the water features. We didn't want to start all over because we had a building to open for our clients, and we needed the water features to finish the building.
Is that when you got in touch with the San Diego Sheriff's Department?
Yes, my boss had asked me to do that.
Okay. Now, you mentioned earlier that the defendant had asked for additional funds. I'm going to show you what's been marked as 771 and see if you recognize this.
Okay.
Do you recognize that?
Yes.
Was that a document that you had received?
I don't know if we received it or if we created it so we could get the water features.
Attorney Nicole DeBorde is on the line with me here on the Law and Crime Network, listening to this testimony as the evening rolls along here. So, Nicole, I thought this got really interesting, trying to unravel where the money was flowing. Why is it that the defendant is telling people who owe the company money to pay him personally? Is there a nefarious reason for that, or is there a less than perfect but honest reason for it?
Sure. I mean, certainly that's the prosecution's theory here, and reason for these killings is that he was in the process of stealing funds from these individuals and wanted to cover his tracks. So the testimony, while a little bit more dry than what we're hearing certainly on the forensic side, is very important to the prosecution's case.
Yeah, and following the money gets a little bit dry for jurors, but that's the crux of this case. It might show a possible motive here. The state says it does show the motive. But look,
exactly,
I mean,
and certainly hearing it makes you think there is one.
Yeah, a couple of different theories behind it. Look, we're going to listen to some more testimony from that business associate who was on the hook paying money to the McStay family company. More from her.
Bottom, and it says $12,750. Is that correct?
Yes.
And this was an invoice from Earth Inspired Products to your company, correct?
That is correct.
And the date of the invoice is February 2nd, 2010 in the upper right corner?
Yes.
Okay. But you don't know when this invoice was generated, do you?
I've seen this invoice when I got involved. I can't tell you what date it was created.
Objection, foundation.
My question is, you don't know when Earth Inspired Products would have typed up this invoice, do you?
No, I can't say I know when you typed the invoice.
What about the date that your company would have received this invoice? Do you know when that would have been?
No.
No?
No,
Okay.
I wouldn't know.
But is there anything on this invoice to show that your company paid the invoice to Earth Inspired Products?
10, it says deposit receipt attached.
Okay. So, and you would have paid, and generally the instructions would be on, you would follow, that would be on the invoice, correct?
That is correct.
Paid. Okay. So I'm going to direct you to the bottom of this invoice. You can take a look. The copy's bad, so let me see if I can zoom in. Okay. Does it say where to pay the $12,000?
Yes, to Dan Cavanaugh.
It's actually misstates the
Oh, wait a minute. Let me read
document.
this.
Go ahead and read it.
That's what it says.
So your instructions were to pay Dan Cavanaugh that $12,000, correct?
I didn't instruct anybody to pay this, so I just want to be clear on that.
But those are the instructions to your company. I'm not saying that you did.
Okay, yes.
Okay. So, and your testimony was that you guys actually paid that $12,000, correct? Or
Actually, misstates
$12,750?
testimony.
Sustained.
You were expecting the waterfalls, right?
The water features, yes. At this point, we were to pay 50% of the water.
We had a couple of people who owed money to Earth Inspired Products. That's the McStay family's company. And they were back and forth. Some were paying Chase Merritt, the defendant. Some were paying Dan Cavanaugh. Cavanaugh is the guy who the defense says should be the man sitting in the defendant's chair, but he's not. Nicole DeBorde on the line with me now. Look, again, is this something nefarious, or is this just a symptom of a small company whose leader disappeared and everybody's trying to figure out how to pull the strings together because the company was kind of on the margin financially?
You know, certainly the prosecution is going to say, you know, this was just a little bit of disorganized accounting, but that there isn't an additional person who should be brought to court. And certainly the defense is going to say, you know, look, there may be motive here, but it's not mine. It's the empty chair there in the courtroom. You've charged the wrong individual.
There's a lot of characterization going on here and not a lot of hard facts. And that's the concerning part, at least in my opinion. Maybe, Nicole, you agree with me. We have to take a quick break, though. Again, court is in recess in the McStay family murder case out of Southern California. We are monitoring the situation. As soon as testimony resumes, we'll bring you back to court live. There's been a lot of testimony from the medical examiner. We'll have to wait and see who's next when we return after this quick break here on the Law and Crime Network. Bottom line, you will not want to miss what's coming up next in that case. We are going to listen back as court remains in recess in the McStay family murder case to some testimony from this afternoon from Jeffrey Martin. He was a business associate whose company had dealings with Earth Inspired Products. Earth Inspired Products, the company owned by Joseph McStay. And here's the thing. The question is, where is the money moving around after the McStay family disappeared? The company was still attempting to function at the hands of the defendant, Charles Chase Merritt, and also a man named Dan Cavanaugh. Now, Merritt is the one sitting on trial here, accused of killing the McStay family. Merritt says Cavanaugh is the guy that prosecutors really should have been looking at, and some evidence that we just listened to before the break tended to point towards money moving in Cavanaugh's direction. But this next string of testimony indicates money was moving the other way. Let's listen.
It's addressed to somebody, correct? I think it's the name you just mentioned.
Yeah, Christina Martini. She's was an interior designer for us. She's no longer with us.
Okay, but that would be the person that would have, at least based on your knowledge of how your company works, would have had the contact with Earth Inspired Products?
Correct.
Okay, and that person would have done, Ms. Martini would have done the, I guess, the work related to getting this first initial invoice to your company, correct?
Correct.
All right. And so, do you know who she was in contact with at Earth Inspired Products?
I don't.
Were you aware that Mr. Merritt, the person that you were speaking with, and that was sometime later, correct?
Correct.
That he is not an employee of Earth Inspired Products?
Objection assumes facts not in evidence.
Objection sustained calls for speculation by this witness.
Do you know what Mr. Merritt's relationship was with Earth Inspired Products?
Objection speculation.
Overruled if he has a basis.
The conversation I had with Mr. Merritt indicated he was a partner
a partner with Earth Inspired Products?
Yes.
Okay. Why would you make the check out then to Charles Merritt as opposed to Earth Inspired Products or the company?
The conversation I had with him went along the lines of, I'm not getting paid. If you want my help on this, I need you to pay me.
Okay, there you heard a man who owed money to the McStay company talk about Chase Merritt. And Chase Merritt saying, I'm a partner of this company, but pay me directly. Nicole DeBorde, this to me was one of the more key pieces of evidence as to the financial motive the state is alleging. Why would Merritt be saying pay me and not the company?
Because he wants to steal the money. And that's what the prosecution wants this jury to hear, that there was a reason that he had to eliminate the people that he was stealing from so that he wouldn't get caught.
Yeah, okay, I get that, and I understand the prosecution is going to argue that, but this is another piece of evidence that can be characterized two ways. I don't see a clear smoking gun here one way or the other. We listened to the interrogation recording the other day where the defendant told officers, Joseph McStay and I were always owing one another money. Is it possible that McStay owed him money and that he just told this accounts receivable to pay him directly? And look, I'm sure accountants watching would throw a fit about that deal, but is this just his simple way of trying to make sure that he is paid what is owed to him because he had some medical bills and his rent was coming due?
Surely that's what the defense will want the jurors to believe, that this was just a quicker way for them to resolve their accounting differences, but I think that's a little bit difficult for most people to buy.
I would agree with that as well. I'm curious to know what Chase Merritt's experience is in with accounting matters at this point. Nicole will talk again here as things move along, I'm sure. Live testimony, though, has picked up here in the McStay family murder case, so let's go back into court live. Bring you right straight back into live testimony from a medical examiner facing cross-examination in the Charles Merritt murder case out of Southern California, where that defendant is accused of killing a family of four. The husband was a business associate of Merritt's. The big point of contention here is how much blood loss would have resulted from the wounds the victims received. The state believes the victims were killed with a sledgehammer found at the scene where the bodies were buried out in the desert there in California. The medical examiner said during direct examination, some of these wounds wouldn't have broken the skin, and therefore there would not have been a lot of blood loss. Well, now she's admitting just how much blood would be lost. She said it would have been pooling. Why is there not blood in the family home where the state says the family was killed? We're going to have to wait and see how this rolls out. For now, back to live testimony. This is live coverage of the McStay family murder case out of Southern California. Attorney Nicole DeBorde is with me here. So, Nicole, it looks like cross-examination of this medical examiner is wrapping up. I keep going back to the key point here, and the defense seems to have deconstructed her initial testimony that these wounds wouldn't have caused a lot of blood loss. I think they did it rather successfully.
I have to agree, and this is such a strange issue, in my opinion, for the prosecution to have dug in on. I mean, the reality is it doesn't really matter where these complainants were killed. What matters is that they were and who did it. And now the prosecution is confronted with a situation where they may have presented evidence that the jury finds to be not credible, and that's a huge problem.
Well, look, the state has taken a couple of other risks in this case. There were some that backfired early on, and who knows, this may be one of them, but we never know what the jury's thinking. Nicole, I know you need to sign off, so it's been good to see you here this evening on Law&Crime.
Great to see you as well. Thanks for having me.
Okay, we're going to take a quick break, and we'll be back with more live testimony in the Chase Merritt murder case, where a family of four was found dead, buried in the desert. The question is, who did it? The state says it's the man seated in the chair right there. We'll be back after this.